Hi, I'm Dan Kuperstein, and welcome to this episode of Compliance Minute. On May 18, 2016, the DOL released a highly anticipated final regulation that revises the federal overtime regulations under the Fair Labor Standards Act, or FLSA. Specifically, the final regulation revises the rules interpreting the FLSA's white-collar overtime exemptions and sets forth 4 key changes to the current exemption test. The final Rule 1 increases the minimum salary needed to qualify for the FLSA's white-collar exemptions. 2 increases the total annual compensation required for highly compensated employees. 3 establishes a mechanism to update these salary and compensation levels automatically every 3 years. And 4 amends the FLSA's salary basis test to allow employers to use non-discretionary bonuses and incentive payments, including commissions, to satisfy up to 10% of the new minimum salary level. These changes announced in the final rule will become effective on December 1st, 2016. Notably, the new regulation increases the minimum salary level needed to qualify for the white-collar exemptions from $455 per week, or $23,660 annually, to $913 per week, or $47,476 annually. The DOL estimates that over 4 million more employees may become eligible for overtime pay as a result of this change under these rules. So it's clear that these new rules will have a big impact on employers, but the question often comes up, how will this change in the law affect our benefits plan? Well, the final regulation does not directly address employee benefit plans, but it does note that exempt status often confers additional benefits on exempt employees. And because the rule substantially increases the minimum salary level to be exempt, it may result in a lot of employees being reclassified as non-exempt employees. As a logical next step, this could definitely result in a lot of employees across the country losing eligibility for their benefits. Additionally, employers may rearrange working hours, perhaps either adding or reducing hours as a result of this exemption change. That could have an impact on which employees qualify as full-time under the ACA definition of full-time employee, which is currently defined as employees working at least 30 hours on average per week or 130 hours on average per month. So under the ACA, employers are required to make an offer of affordable, adequate health insurance coverage to ACA-defined full-time employees and their dependents in order to avoid a penalty under the ACA's employer shared responsibility provisions. So it's definitely something that will likely have at least some impact on benefit plans. For more information on this and other topics, please visit our Knowledge Center at corpsyn.com. Thank you.